Angie has made it easier than ever to hire high-quality pros to get all your home service jobs done well. Just bring them your project online or with the Angie app, answer a few questions, and Angie will connect you with local pros who match your specific needs. Or book a service instantly at an upfront price. So join the millions of homeowners who use Angie to care for their homes and get your next home service job done well. Download the free Angie mobile app today or visit Angie.com. That's ANGI.com.
At Evernorth Health Services, we believe costs shouldn't get in the way of life-changing care, and we're doing everything in our power to make it possible. Behavioral health solutions that also keep your projections at their best? It's possible. Pharmacy benefits that benefit your bottom line? It's possible. Complex specialty care that cares about your ROI? It's possible. Because we're already doing it. All while saving businesses billions. That's Wonder made possible. Learn more at evernorth.com/wonder.
We had such a contentious relationship between me and my two siblings that they went and contacted Family Services and made claims that I was abusing my father and I should be arrested.
This is the plaintiff, Keith Gruber. He says the defendant, his younger brother, stole a Marc Chagall painting of their late fathers that he was supposed to sell. He has no idea where the valuable painting is now, but he wants his money and is suing his sibling for $5,000 because he out and out stole it. This is the defendant, Jonathan Gruber. He says he and the plaintiff haven't had a relationship in over 30 years, so he's not surprised his brother would drag him into court today. Bottom line, he had the painting appraised. It was deemed a fake and worth nothing. He told his brother he was free to try to sell it to see what he could get, but first he had to return that jewelry he stole when their mom died. Oh, him? Ah! He's accused of pilfering a painting.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Millian in our forum, the People's Court.
Be seated, come forward, please. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Keith Gruber?
Yes.
You are suing your brother, Jonathan Gruber?
Yes.
For $5,000, the amount that you say you are owed for your third of a portion of a Marc Chagall painting that your brother was in charge of selling and distributing to the three brothers as representative of the estate. You're suing him as representative of the estate. All right. What happened?
He was named executor for my father's estate. My mom had previously passed a couple of years before.
When did your father pass?
February of 2010, February 3rd. And we had a contentious relationship. It was really bad prior to that. I mean, really bad.
Were you on speaking terms?
Not at all.
How long had you not been on speaking terms?
Off and on for, I guess, for like 20 years.
Okay.
And it got to the point where I had gone down because my father had gotten ill in December of 2009, and I went down there to take care of him. And he was
down
in Florida.
Okay.
And he was put into an assisted living because he was really ill. And I took care of helping him out and doing things for him. And my father had named me his medical proxy. And we had such a contentious relationship between me and my two siblings that they went and contacted Family Services and made claims that I was abusing my father and I should be arrested.
Okay. So there's three boys?
Yes.
Okay, three men. And nobody gets along, or is there...
He gets along with the older one.
Okay. And you are the youngest?
I'm the middle.
You're the middle. All right. Tell me about that claim about contacting the Department of Health and...
I don't know anything about it. That was something, excuse me, that was something that my other brother may or may not have done, so I don't know.
Well, you must have heard about it, because that's pretty...
My father was in an advanced state of cardiac failure. He was dying. And he was lifting him up, taking him out of the hospital in order to do banking things and estate things and to change things.
Carrying
around.
him to the bank?
Yeah, well, putting him into a van, or my father's van.
From his home?
From the assisted living.
From the assisted living.
Taking him out of the assisted living, carrying him to the van, and driving him around in the debilitated state that he was in. That's what I heard.
Was there a doctor that said that he couldn't bank with his son? Because, I mean, I understand. See, here's the thing. Was there money in the estate?
Yes.
Yeah, that's where everything hits the fan. So what happens after that claim? Where did that claim go, by the way?
He was shocked by what they said to him. He said, I'm in an assisted living. What kind of abuse could he be doing to me?
Okay, so did your dad call the older brother and say, what are you doing?
Yes. And he told him, listen, cut this crap out. Excuse me, my French. You know, I don't know what the hell.
French?
I don't know what the heck you guys are doing, but stop with this bull. I'm fine. You know.
All right, let's move on from that and let's talk about what happens then in 2010. Your dad passes away. And did you know that he had named, you're the middle one, did you know that he had named little brother, the defendant, as the executor of the estate?
Yes.
You did know? Okay.
Yes. The night before.
What do you do for a living?
Right now, I'm not working.
What's your profession?
I worked as I ran wine tours to the east end of Long Island.
Okay, and what do you do for a living?
I'm an attorney.
Are you practicing?
No.
Okay. When did you stop practicing?
2 years ago.
You retired or?
Semi.
All right, so now the subject of this particular, I assume that there was more involved in this estate than the subject of this lawsuit, correct? Okay.
Correct, Your Honor.
How much money was involved in the estate? Roughly.
Cash-wise, about $130,000.
Okay. There's actually two pieces of art. One of them is the subject of this lawsuit. The other one you plan to take to court on a later day, probably because of statutory max here. And then, according to you, there is an unresolved matter about some jewelry that we'll talk about in a second. Okay? Is that all that's left on the estate? Because everything else has been divvied up and there's no dispute about everything else. I'm just curious.
Yes, Your Honor.
Yes, and yes. Okay. Now, your dad passed away in 2010, but in 2011, the three brothers enter into a written stipulation about several things, including a work of art, a Marc Chagall, that no one knew the value of. No one knew if it was real, if it was fake. Did you ever see it with your eyeballs?
Yes.
Okay. What was it?
To me, from what it looked like a charcoal etching, sketching.
Original.
Yes.
That's what it looked like to you?
Yes.
Okay. So you folks enter into an agreement in 2011 to have that thing appraised. Did that happen?
I tried, but no.
How did it not happen?
I went to a appraiser called Swan.
Okay.
And in terms of Swan, they finally took a look and they said, this isn't anything. And they turned it over, which of course I hadn't really thought about. And they said, look, right on the back here is a number, and it's like 42 or something like that. And that's a page number. It's a page number in an art book. This was taken from an art book, ripped out, and framed. So my parents apparently at some point bought a nice book of art that they had this Chagall in there. And they said, oh, this is nice. And they cut it out neatly, and they framed it or had it framed, and they put it on the wall.
According to you, you got this information from an auction house or an art appraiser in 2011.
Yes.
Did you convey that information to your brother pursuant to the stipulation you had all signed to try to keep some peace and get this resolved?
Yes, through the attorneys.
Okay. May I see any evidence of that appraisal?
No, that was just a verbal thing. He said it's worthless.
You're the executor of the estate. You have a piece of property and a very contentious relationship with one of the heirs to the estate. There is a legal written document that says you must get it appraised and sell it, and if you can't, then you must give it to me to get appraised and sell it. That's what the document between you two says,
yes.
Right? So that I can have a chance. And if I can't sell it, then I give it back to you and you keep trying to sell it, right? That's what
yes.
the legal document said. You're a lawyer, right?
Yes.
Okay. Your answer to the court is it was verbal, and where's the piece itself? Is it still here?
No, the piece is, I gave it to him. I don't have it.
That's not what you said in your answer to the complaint. You said, I don't know where the piece is. For all I know, I might have given it to him. I have no idea. Watch this. Did he give it to you?
No.
Okay. So now what we're left with is this. You have a responsibility as the attorney who is in charge of the estate to have some answer to the heirs on what an asset is worth. If the answer from the auction house was, this is garbage, then you ask them to put it in writing and you distribute it to him and his lawyer and everybody else involved. Where is that?
That didn't exist, Your Honor. What I'd like to point out, and you raise a great point here, but I have photocopies of the art that we're talking about.
How do you have a photocopy of the art and not the art?
Exactly. The reason why I have a photocopy of the art was because I knew it had to go away. Either I had to have it appraised and sold off, or I had to give it to him. So I made a photocopy for myself. And on the photocopy...
If you kept the photocopy, why didn't you keep the art? Why didn't you comply with what you had agreed to do, which is if you can't sell it, which apparently that's what you're saying, you couldn't sell it, why didn't you, after the 120 days that you had to sell it, then comply with the agreement, which was to give it to him, for him to try to sell it? Why didn't that happen?
That did happen. I have an email from his attorney to me stating just that.
Let me see the email.
That's it.
You know what I'm looking for, right? Because you're an attorney. You know, so even if you weren't an attorney, you should know what I'm looking for. I'm looking for any evidence of anything that you no longer have this asset, weren't able to sell it. I'll forgive that you don't get in writing that it's worthless. I'll forgive that part if I can see that you then took the item and complied with the settlement agreement that you have with him and handed it for him to sell. If you can prove to me that that happened, you're in the clear. Is that what that is going to prove?
If you look at the bottom of that page, that's where I discuss that I'm dropping off the art.
Except for you didn't drop it off. Because in your answer to the complaint, you say, I'm going to go to my aunt's house and I will drop off the art for him to sell. And at that time, I expect him to give me either some jewelry from a prior agreement that he didn't give up and distribute fairly, or the money from that jewelry that he didn't give up or distribute fairly. You bring up something that is not in the stipulation, right?
That's correct.
Okay. Then when you get there, he doesn't have the jewelry or the check. So you don't leave him the art. That's what you said in your answer to the complaint.
That's what I thought initially. After looking at this over the past time since I've been...
You decided to change what you said in the answer to a week ago?
No, I understood what happened better. I remembered better. I went through all the documents.
That's great. Can I just tell you something? I don't want to hear your flapping gums anymore. I want some evidence of what happened. You're the executor of the estate, and you have a responsibility to every heir in the estate, including the brother you don't talk to because you don't like him, because he's a jerk or whatever else that you haven't talked to in 20 years and you've had this contentious relationship. You have, if anything, you should have been extra careful to cross every T and dot every I in this situation.
When I initially took possession...
By the way, you said I was going to see in that email from the lawyer that you gave him the artwork. I didn't, did I? There's nothing in this email that says you gave the artwork, right?
That email says, I am traveling to my aunt's this weekend, and I will be dropping off the art.
You know the difference between past tense and future intent, right? This says, I'm going to do X. You told me already in your answer to the complaint that you didn't do it because you didn't have the jewelry and the money. So this does not acknowledge by a lawyer that you gave the artwork to your brother or the brother's lawyer, does it? Yes or no? Yes or no?
No, that does not say.
Now all I need, my needs are super simple. And if you need me to take a recess, I will. I need proof of what you are talking about. I need proof that the thing isn't worth anything. If I gave you the opportunity, which I shouldn't have to give a lawyer, but I will, because I really want to get at the truth, okay? If I gave you the opportunity with a room and a telephone and a computer, would you be able to get records from these auction houses?
Your Honor, this is the
truth. Yes or no?
I don't need it. I have it right here.
Welcome back to the People's Court. Harvey Levin here. Why do brothers and sisters fight so much when parents die?
I don't know. I think just in that moment, there's a lot going on emotionally, and so...
Okay, well, do you think it's emotional? Is that why?
I think they want to avoid probate. No, I think that there's a lot of things going on in their heads, whether or not they're the favorite. Why did mom leave you this and not this? Like, who gets the house?
You're getting warm.
I would say rivalry and greed.
Okay, it's sad, but I think everything you guys said is probably true. Going inside the courtroom.
This is the truth right here.
What is that, my dude?
This is a photocopy of the art in question. This photocopy has a date stamp on the back. Why am I making photocopies of something that I'm keeping? Why would I ever do that? I would do that because I'm getting rid of it. I'm giving it to him. I have this because this was a lovely piece of art that my parents had hanging.
You call that evidence that I should hang my hat on? I should look at, Judge, why would I take a, you should trust me, why would I take a photocopy of someone unless I gave it to that guy? That's your evidence of what you did with an asset of the estate? Do you or do you not want an opportunity? Don't tell me what you think is sufficient, because I am here to tell you that it is not only not sufficient, it is woefully insufficient. Now, if you really got that assessed, they will have a record of it. Do you want an opportunity? Maybe they don't keep records that far back. Maybe they do. Would you like an opportunity?
No, thank you.
No, you wouldn't, would you?
That's funny. Yeah.
No,
you think that's
wouldn't.
hilarious?
It's not. It's pathetic, dishonest, and I am sure that your father is rolling in his grave right now.
Sure.
Verdict for the plaintiff. In my guesstimate, I have to do a guesstimate. So now, let us see, which is virtually, I mean, I'm in this position because the executor of the estate doesn't bother to take his responsibility. You know what? $5,000 verdict for the plaintiff.
Thank you, Your Honor.
Well, there comes the defendant. The executor didn't quite execute. What's your reaction to the outcome here?
This was resolved back in 2011, excuse me, and I'm not going to keep these things forever.
What was it like to be in the courtroom opposite him after such a long time, not seeing him?
I didn't see him then either.
You didn't see him just now
No.
in the courtroom?
No.
Why not?
Why?
Why what?
Why would I look at him?
That's what I'm asking you.
There's no reason to.
Sir, if you would, right, sir.
All right, what's your feeling on this situation?
You know, as I've known all along, the deceptions that, you know, I had to sue him to get my share of my, you know, my father's estate. It cost me a lot of money to do that. I knew this was going to be like this. And
What was this like for you?
it was hell. I mean, I have no relationship with him, and I have no relationship because of that with my niece, because he won't let me have a relationship with her. And it's hell. It shouldn't be like that. But him and my older sibling, you know, this is how they were, and they tried to take all my dad's money, and I fought them every step of the way.
All right, Harvey.
I got to say, you know, at a point when push comes to shove, when you're at this point, you just got to sue your family member. That'll do it for this case. Litigants for the next case on the way into the courtroom right now.
Angie has made it easier than ever to hire high-quality pros to get all your home service jobs done well. Whether it's routine maintenance, an emergency repair, or a dream project, Angie lets you compare quotes from multiple local pros, browse homeowner reviews, and even book a service instantly. Angie's been connecting people with skilled pros for nearly 30 years. So the next time you have a home project, bring it to Angie to get your job done well. Download the free Angie mobile app today or visit Angie.com. That's ANGI.com.
This is the plaintiff, John Cathcart. He says he rented an apartment from the sketchy defendant. And now that he's moved out, he's having one heck of a time getting the defendant to reimburse him the money he owes. Not only was the apartment uninhabitable, it was dangerous and noxious lead paint peeling from the walls. And that's a big no-no these days. He's suing for $950, the money he's due. This is the defendant, John LaSala. He says he put a lot of time and money into the apartment the plaintiff rented from him, and then he subsequently moved out before his lease was done. He purchased new appliances for the guy, painted the place, and the plaintiff turns around and breaks his lease on him. And he wants a full refund? He thinks not. He's accused of dangerous landlording. The defendant has filed a countersuit for $500 for a return of monies owed.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket, the plaintiff rented an apartment from the defendant, and it was uninhabitable with lead paint, for crying out loud. But the defendant says the plaintiff jumped out of the lease. It's the case of get the lead out.
Thank you, Douglas. John Cathcart?
Yes.
Cathcart, sorry. You are suing John LaSala for $950, the balance of a security deposit that, according to you, he owes you. You have a counterclaim against him for $500 that you want returned in a settlement check that you wrote to him that you don't feel he deserves. What happened?
Let's see. So in early July, I thought I found a new home, and I found a new place from this gentleman here, and I loved it, and I thought it was great, and I moved in, and I said, but agreed upon, before I can move in, this and that and this and that needs to be fixed.
Is that in the lease?
That was not in the lease. That was just a handshake agreement.
Okay. Do you have it in an email?
No, there was an email. I think I sent him an email over that about.
You did or you didn't?
I did.
May I see it?
I don't have it.
Oh, okay. I was referring to proof. Okay, so go ahead.
So those things were not fixed.
What things?
This sink didn't work.
How did the sink not work?
The left side of the kitchen sink did not move at all. Like, you turned it in.
Are you referring to the faucet? Are you referring to the drain? What are you referring to?
The faucet.
Okay. So go on. What else didn't work?
The floor was broken. It was giving me splinters. And
how was the floor broken?
The wood was cracked.
Was all this stuff new, or is this how you rented it?
This is how I rented it. And I said, before I can move in, these things need to be fixed.
But then you moved in and those things hadn't been fixed, right?
They hadn't been fixed.
So why did you move in?
Well, I moved in.
Did you just change your mind about living there? Did something come up and you changed your mind about wanting to live there?
At the end of the month, the first month.
How long did you live there?
I lived there 2 months.
Okay, what's going on? What happened? You get notice that he wants to leave when?
Notice that he wanted to leave came in September.
And he had moved in when?
July 1.
Okay, and what do you think happened? Or did he give you any inkling? Did he tell you why?
No, he signed a year lease on July 1st. He provided 1 month rent for July and 1 month security. The lease is pretty specific with respect to the as-is. I just don't know.
And so what happens? He tells you he wants to move out, and what do you say?
I said, well, we signed a year lease. And he said, yeah, I know, but things aren't going well. And, I tried to work with them and said, well, what are we going to do? If we can get a replacement tenant, I can allow you to break the lease.
Did he get you a replacement tenant?
He did.
Okay, and then what happened?
On October 1st, the replacement tenant moved in. At that point, he had paid me first month's rent.
The new one?
No.
No, him. Okay, he had paid you first month's rent and?
A security deposit.
Okay.
And then a rent for August, right?
Okay, so according to you, he didn't pay September?
Correct.
Okay, so how much was a security deposit?
1 month rent.
14. Which is $1,450?
Correct.
All right, so if you're owed $1,450 for September, which is what you're saying, right? Then how come you returned anything to him?
To not have to be here.
Oh, how'd that work out for you? All right, so did you pay September rent?
Yes, and I have proof and
May I see that?
Yes.
I need to see now proof of rent from July through September, not just that you paid a rent in September, because I got to make sure it's not August's rent. Do you have everything, or do you just have September?
This is September.
Okay, but you have access to it all, right?
Yeah.
Yeah, you can get it on the internet? Mm-hmm. Okay, so let me see that. I'm sorry, what is this? This is something you printed up. Okay, this is your notes. After arguing I should get my time, then this is your cut together thing of some text, and then these are words on a page. I need the bank statement. I need to see that there was a completed payment that you didn't stop payment on. Did you get a September rent check from him at all?
No.
All right, we're going to take a recess, and you're going to log into your bank account, and we're going to try to see if we can come up with the answer of how many rent payments you made. But it's kind of confusing to me because you, according to him, in order to not have to go to court, he said to you, and I see it in the text between you two, listen, do you want to just like settle this and I'll make you a $500 payment, and you say okay, right? So you agreed to settle it. Right?
Yes, I agreed to take the $500.
Right, but then you came to court anyway.
Mm-hmm. Yeah, and then after the fact, after consulting with several people, and they said, no, you need to...
I know, but what do you think? You think there's no legal effect to settling a case? Like when you say to somebody, yeah, fine, I'll take $500 and we're even. But see, the problem is I still have to get into whether he paid rent because now you want your $500 back. So court is in recess.
All rise. So if a tenant really falls on financial hard times and they can prove it, can they get out of the lease and avoid all that responsibility?
I wouldn't think so if you signed a contract.
But is there any hardship exception if you sign a contract?
There may be. There may be laws or different lawyers who fight for people like that.
What are you saying?
No, you can't break the contract. Once there's a contract.
Even for hardship?
Hardship, no.
Okay. Going inside the courtroom.
I now have made you go get your bank records. I have the lease that you signed. Your bank records show that you paid July in July, at the beginning of July, you paid July, which is your first month according to your lease, and you paid a security deposit. When August comes, you pay nothing. And then on September 1st, you make a payment. That goes to paying August, so you still owe September. So no matter how you slice it, why did you pay the guy $500?
Good question.
Do you understand? You used up your security with August non-payment of rent, unless you can show me that you paid August somewhere.
See, it was agreed that my first month's rent wasn't until August, so that...
Okay, you do know that this belies what you're saying. This does not agree with what you're saying. Your lease... When did he actually move in?
July 1st.
Okay.
I have proof that there was work being done. I couldn't live there the entire month of July.
Okay, show me the proof. Do you have text back and forth where there's a delay and he can't let you move in because there's work being done? Show me something.
This text on July 19th.
Okay, let's see it.
There was work. There was a worker staying overnight, and.
Can I actually see it in your phone rather than you cutting and pasting stuff? Because that makes me nervous when I see that. Let me see your phone.
See it on my phone?
Exactly. Do you have your telephone with your text back and forth with him?
I don't have text back.
I see a text from you that he's taken a screenshot of. I'm going to see it in its context now, where you say, "Hi, Johnny, just by way of update, I have been speaking with Richard. He is at the building now, working away overtime and proceeding as planned. He should be providing an update later, although he tends to work into the night sometimes." Why would you be telling that to somebody who's already living there?
This was in connection with some window painting that had to be done around the window. He's an on-premise super that does a lot of work while people are in occupancy.
Do you have any proof that you didn't have to pay July rent? That's what you're telling me. Judge, I didn't have to pay July rent. I need proof of that because your lease says you did. And all this says is somebody's working late on the, on repairs. That's it. It doesn't say that you're not living there.
Yeah, it was a handshake agreement that work was being done and I couldn't live there, so.
All right, and now you end up paying him $500 that you don't owe him. Because that September payment was for August rent, and then the September would be eaten up by the security deposit, which would leave you in a position where he's breaching a lease with you. Why would you pay him $500 unless, in fact, you had told him don't move in? Because when you say, oh, well, not to be here, that doesn't matter. Why? Because what? Because you wanted him to move out swiftly? What?
I'll explain exactly, as I mentioned before, to not have to be here. I didn't know what was going on. I didn't want to explore it anymore. Look, I get it. He was helpful and instrumental in getting, showing the new tenant, the October incoming tenant, the place.
Yeah, but that's his obligation. That was how you told him he could breach his lease. No. Okay. All right. So are you able to find any proof of the things you were saying? Nope. Okay. So on your lawsuit against him, for the remainder of your security deposit, my verdict is for him because it doesn't appear that you have a security deposit left. On your counterclaim against him, for the $500 that you paid to him in terms of a settlement to not have to come to court, you have breached that by then fully intending to come to court and coming to court and then doing that. So I'm ordering you to pay back that $500. That's my judgment. Good luck, folks.
Well, the plaintiff comes out with nothing and even loses on the countersuit situation. So step in here and give us your reaction to this this verdict right here, right there. Good.
See, I don't believe he's a inherently dishonest person. I think he ignored a lot of his responsibilities, and I should get my full deposit back, and then not have to pay for July.
If that's the case, you should have gotten that signed on paper, too.
I should have.
That would have
and I didn't, unfortunately.
Okay. All right. Around the corner this way. Documents are waiting for you right there. Sign those. All right. So step on in here. And all right, you went on your countersuit. What's your thought here?
Don't get into the real estate business. These are par for course, I think, just misunderstandings, miscommunications, and things that have to be contended with.
Why not get into the real estate business?
You're doing a lot of variables. It gets very emotional, and people.
Are you getting out of it?
Not just yet.
Okay, Harvey.
Technically, Kurt, landlords are not allowed to use their security for last month's rent. The reality is, most of them do. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.
This is the plaintiff, Tiffany Simone. She says she's an author, and she rented a party space from the defendant for a pre-release party for her new novel. In a moment of confusion, though, she overpaid the defendant, in essence paying her twice for the party space, and the woman refuses to return her overpayment. She has no choice but to sue here and now for the $400 she's owed, and that's just what she's doing today. This is the defendant, Adrian Ferguson. She says the plaintiff didn't make the food and bar minimum they agreed to, and in reality, the woman still owes her $300. She was willing to just let it go, but the plaintiff is making a big stink out of it because she thinks she overpaid, which she didn't, so here they are. She is accused of trying to take advantage of a mistake.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff rented space with the defendant for a book party for her new novel, but says she double paid. The defendant says it's her who's owed more. It's the case of a novel party.
Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
Okay, Tiffany Simone.
Yes.
You are suing Adrian Ferguson and Billy's Black Bar Lounge. You're the owner?
Yes.
Okay. For $400 that you say is owed to you in overpayment because of a contract that you had with her to have a party there, and according to your reading of the contract, she owes you $400.
Yes.
Your reading of the contract is slightly different. Let's first talk to you. What kind of party was this that you were throwing at that establishment?
My pre-release book party.
Okay, because you wrote a book?
I wrote a novel, Falling Petals, and I kind of wanted to do a pre-release, get some opinions of some of the people, put the book out there, and let people know what's going on and what I'm doing.
Were you self-publishing, or you were?
I was going to self-publish, but then I pulled it back because
so this is pre-release then?
Yes.
Okay.
Yes.
All right.
Very
So you wrote a book, and then you wanted to have a party and kind of promote it, and were the people there people who had read it?
Yes.
Okay. So how many people did you have?
I would say roughly maybe 30 people came out. I took some pictures. We had plenty of pictures.
Okay. So you would say about 30 people attended?
About 30 people.
Is that accurate?
No.
How many do you say attended?
About 50 to 55 people.
How do you know?
Because our restaurant seats 50 people, and there are a few people standing.
There was someone sitting in every one of those 50 seats?
Every seat.
And then there were a few people standing?
Yes.
Is that part accurate, that there was someone sitting in every seat and there were a few people standing?
It's not totally accurate because the restaurant was open to other people. So it wasn't like it was closed exclusively for me.
Okay, ping pong, ping pong. Is that accurate that the restaurant was open to other people during that party?
Yes.
Well, then how do you know how many people were her guests and how many people were not?
Because she sold tickets for the event.
Okay, who did the selling of the tickets?
Miss Simone.
How do you know how many tickets she sold?
I don't know how many tickets she sold.
So you're guessing.
Right.
You're
Well,
kind of guessing.
I'm not guessing because she told me that originally that she was going to have about 40, at least 40 people to the event.
Okay, so we're from 55, now we're down to 40, but you don't know beforehand how many people actually go. So if you're not in control of the door, it's a guess about how many people went, right? How many people, according to you, how many people went? 30?
About 30.
What's about 30? How many people went? Because if you sold tickets, you know how many people went. How many tickets did you sell?
About 20, but some of the people that came, my video person that was setting up the video screen, then you had the DJ, and then you had...
So you seated them? And even with that, it's only 30?
Yeah.
Okay. Now, what was the agreement you guys had?
The contract was through email.
It's the first email and then the second one.
Let me see all of the emails governing any of the agreement between the two of you. Okay, so you sent an email to her saying, I'm looking to pre-sell tickets at $25, $15 for an autographed novel copy, and $10 goes to the house and should be used towards drink and or entree. You respond, okay, at $10 per person plus a bar guarantee of $400, meaning that your guests will order as normal, and at the end of the night, we calculate all that sales during the hours of your event, that should reach the $400. I'm not understanding. What's the deal you're offering her? Because I understand the $400 because you explained it, but I don't understand the $10.
Okay, so she had ticket sales at $25, and $15 were for the book, and $10 was, in essence, a discount for
the food.
For the food.
Okay, so she's going to pay you the $10 per person.
Yes.
Did you not get that?
I didn't get that.
Well, but when in your email you say $10 to the house, how did you not get that?
No, $10 to the house, but it was towards the $400.
Yeah, but it's towards something. That means that she's got to discount her food. Like her food costs. If somebody orders $20 worth of food and they're only paying $10 for it, you know, she's supposed to get the other $10. That's what $10 per person means, right?
What I'm saying is, to get to that $400, I gave a $200 deposit.
In the end, you ended up paying her $400
altogether.
Cash,
yes,
yourself. There's no dispute about that. Correct. Let's put that to a side a second, okay? But what did you? Before we get to that, I want to get to what you thought the agreement was.
That the $10 was going towards the guarantee.
$10 going towards the $400.
Yes.
But now you paid $400, and then you collected the money at the door, right?
Yes.
But you feel like because the agreement should be read the way you're saying, the only thing she should get is the $400 and not what people ordered?
No, she did. She did get what people ordered. Her tab, when I sat down with her.
So she collected more than $400.
Of course.
So you feel like your $400 goes back?
Yes, because that was the deal. Because at the end of the night, she made over $900.
Okay. Is there any dispute that you collected $900 in revenue that day?
No, her party yielded about $655.
What evidence do you have to show me about that? Because she says you showed her $900 worth of stuff.
Receipts.
No,
that night.
These are the receipts here.
Who keeps tabs that night? You do?
Well, the bartender.
Is that the bartender you just pointed to? Come on up, bartender. How do you know if people are hers or belong to somebody else?
You really don't. But in that particular instance, the time frame that her party was, it's all accumulative. I don't try to decide who is who. I just add it up all together based on the time frame.
I know, but that's not the agreement between those two.
Right.
So I don't blame you.
So who here thinks they may have the great American novel in him or her? Really?
Yep.
Give me it in 12 seconds.
I'm a former Army Ranger, got out, tried to be a cop, messed that up. Hit the streets for a while, went to college, got my law degree and MBA, messed that up, and now I'm in rehab. And
okay, stop. We're out of time, but you may have it. You may have it. Going inside the courtroom.
So now these little drink tickets that are attached to this, what are these?
They are the tickets that she gave them in order to get $10 off whatever.
Okay, why don't we just count these? These will tell us how many people were there. Has anybody counted them?
Yeah.
I can't believe you keep these.
It comes out to 18, but that would mean that's what she gave them as far as the discount is concerned.
I'm rereading your email. Let's look exactly at what you say. At the time that you guys are reaching an agreement, because the only thing that's relevant to the court when we're trying to figure out what the contract is what was the agreement between everybody before the event happens. So there's what you folks appear to have agreed to, which is what I've got to figure out. What you think it should be now, what you think it should be now. Those are three different things. All I care about is what it was then. So let's look at it. Let's discuss the process in which we work with events. We can do in making the space available is, as you suggested, at $10 per person, plus a bar guarantee of $400, meaning that your guests will order as normal, and at the end of the night, we will calculate all that sales during the hours of your event. That should reach the $400. If that amount is not reached, you would be responsible for the balance. Okay. What we all know is that the sales reached $400. You think it's $900. She says it's $600 and something. But we know that the sales all reached $400. What you are arguing is there were 40 people there. And therefore, that's why you should keep her additional $400. You don't know there's 40 people there because nobody really took a head count. All you can show to me is that there are 18 tickets sold. So what have we got? We have you being entitled to making sure you make at least $400 in receipts, all of which has been met by your admission. And then, at best for you, you being entitled to $10 for each of the sold tickets. And I agree with you on that, because that's a $10 discount off your prices that you weren't, I mean, that person's getting $10 worth of food from you. So you're right about that. So my next step then in this dissection is to try to figure out how many people went. You say 55, then you say 40, you say 30, and then you say, I sold 20. Well, you didn't even sell 20, you sold 18. All right? So of this 18, an additional $180 belongs to you for food discounts that you gave at her request that you're supposed to be compensated for. So of the 400, 180 is not going to you, because that's owed to her, which means everybody's going to know I can't do this math quickly. $220 is what you need to return to her. My verdict is for the plaintiff in the amount of the $220. Okay? Good luck, folks.
Thank you.
Judge Milian finally unravels this deal, and she winds up with $220 back out of the thing. You have to pay that. What's your feeling on this now, giving some back?
We're not accountable of whose party is who. We don't know any of her people. She knows her people.
How do you keep count of anything?
As long as everyone pays their bill, that's what we're worried about.
Well, you wind up in another dispute next time because nobody knows how many or who's paying what. We'll see you again then.
No,
unless
I don't
you're
think
a little
so.
more specific next time in your contracting.
Yeah.
All right. Okay. All right. All right. So step on in here, and okay, you got some back. Okay, you satisfied?
Yes, of course. Something is better than nothing.
All right. Good. Good. And
especially when you're a struggling artist.
Oh yeah, the book.
Yes.
All right. Tell us a little bit about the book.
It's Falling Petals. It's about a woman that gets sexually abused and the domino effects behind it. Society, family, friends, everybody's affected.
Is it out yet?
Not yet.
You can go to Barnes & Noble and
not yet.
Order it online, Amazon?
We're still working on it.
Still working it. When do you expect it?
Hopefully sometime this year.
Yeah, good luck.
Thank you.
Harvey?
You know, at a point, judges will just throw their hands up and say, I can't figure out what the contract means. Here, the judge was able to figure it out just barely.